technical and procedural errors. It's also been described as administrative errors. They've said that this petition should fall, described as a stillbirth. It's been said to be unconstitutional. It's been said that it cannot be verified. Just some of the submissions that we had the whole day today, but still, Trevor and Gladys, we have pending business. For example, tomorrow the court begins at 11, and one of the issues that they will begin with is a submission from the third respondent. It's not also lost to us that indeed there are other people who have not yet had their time in court. That includes one interested party and two friends of the court, which includes the Law Society of Kenya and the Attorney General. They will be submitting tomorrow, and at around 5 p.m. they expect that the reports from the conditional access of the servers shall have been filed, and the parties will also have an opportunity to present on that. And that's the exact point that I want to begin with my panel, and introducing from my extreme left is Kakai Kissinger, an advocate. We have George Kithi, we have Duncan Okatch, and Moses Kurgat joining me on set right now. And I'll start with you, Kakai. From morning, the first business today for the Supreme Court was to delve into the matter of access to the information as was petitioned by the applicants in this petition.
Yes, and you remember that that's an issue that was pending since yesterday, and it was the first order or agenda of the court, and as expected, because we were analyzing this thing yesterday, and we said the possibility or the likelihood of the court allowing will be very high, and because they are moving away from the 2013 decision, which seems to be haunting the court. And of course, as we suggested yesterday, we realized then today that the court allowed access to the IBC database. Of course, it was limited, and there were quite a number of things that they allowed NASA to do. But then that sends a very good signal that the court is going on board with everybody and wants to ensure that nobody is left out in terms of viewing or reviewing the issues that they might think might help their case. So it's a very inclusive judgment that we saw this morning.
All right. And George, this, as Kakai says, is a complete departure from 2013, because the court has deliberately decided that we're no longer going to measure on technicalities. Bring the substance of your cases here, and let's look at what you have before us.
That's true. What happens is that the court, having made the decision in 2013, I think has learned from it. Most importantly is that it has, although there are some documents that had been filed out of time in terms of affidavits, it has accommodated every party to put in the documents. That means that all the evidence that was material for all the parties to rely on, they've been given the chance to do so. And I think the only issue was an affidavits which otherwise were not germane to the application and as to the petition itself, but were for an application. I think that issue was also sorted out, and I think the parties were happy that because then they had all materials and the latitude upon which they could make the submissions on, either factually or on issues of law. And I do believe that the narrative and reference to documentation was orderly. All the documents were available. There was free flow of that narrative all the way from Orengo's initial submissions, culminating into the closure of the submissions on part of the petitioner, and then, of course, the take-up on that, following through from Paul Muite until the culmination of that with the big words we had from one PLO Lumumba. So I do think that it was a good day for everyone, and the summary made by the Chief Justice is that everyone who wanted to say what he wanted was given that opportunity. I think that's satisfaction Kenyans want to see.
All right. George, try and take us through the, not George rather, but Moses, try take us through the mind of the judges when they decided to do away with technicalities. What informed this? Was it the public outcry following the 2013 throwing out of the 900-page affidavit?
Yeah, thank you very much, Ken, for this opportunity. I think the judges are well-minded to consider the litany of complaints that were raised in the judgment of 2013, and they are interested in breaking away from that tradition whereby technicalities were reigning supreme in matters concerning electoral petitions. The judges have decided that everybody should be on board. Be on board, say whatever they want to say, so that tomorrow when they go out there, they don't have the opportunity of complaining that we were denied a chance to say something. This is an opportunity for everybody who has an issue in regard to the elections to come out strongly and present their case. We will now see, or we have seen today, the way the parties have presented their cases. It is obvious that they cannot complain tomorrow that they did not get the opportunity. So it is a very pleasant situation for me and for every other Kenyan, I believe so, that the legal minds that are handling this case have decided that the Kenyan populace, the Kenyan people, who the petitioners are saying they are doing the petition on behalf for, are now going to see what the character of the petition is, the issues that are being raised by the respondents in opposition to the case. And of course, we've seen varied submissions by all the lawyers, starting from the petitioners' lawyers. We've seen how they've gone through the process in an attempt to prove their case. And by the time of 5 hours, or even more, I think they even extended their hours, they had an opportunity of showing the true character of the petition, and the respondents, on the other hand, then had an opportunity to show also the tests that will be used by the court to determine whether there was a fair and free election in this country.
All right, Duncan, opening these servers for NASA and obviously granting one of their biggest wish means there's something happening tonight and probably throughout the night. Remember, the request was 18 hours, right? And now probably they have begun the exercise. So what is happening tonight?
Mijungu, what is happening tonight is that the servers are being opened in terms of access, but it is important to know that despite the fact that this particular prayer was made by NASA, access has been given to all the parties. Actually, access has been given to IBC itself, who are the custodians. It has also been given to the respondents in terms of the third respondent, that is the president himself, and they will actually have a chance to also see what NASA is actually saying at the same time. So what is happening today is that there is an issue of constraints of time. They were supposed to agree on how to undertake these particular modalities. As you can see, it's a four-pronged approach. So that from what we were hearing is that by even evening, they had not actually agreed on all the issues in terms of how to approach it. But my belief is that by now, and in terms of what we are hearing, they have actually started that particular process. They will do it throughout the night.
Who are involved? Who are involved in this process? In this process,
the court itself has indicated that there will be an IT expert from the court itself, but there'll be one from the court itself, and there'll be two additional ones external, but procured by the court itself to actually guide that particular process. And then the particular parties will actually bring in their people. Their people are people who are incognito, but I believe they should be experts in IT, because the main issue here is how they will get that information, extract that information, and actually synthesize it for the court so that it's in a language that is easily readable to the court. And you remember, all of them will have limited time to submit on that particular report.
And actually limited resources also put here, George, in terms of how many people will be allowed tomorrow to talk about the outcome of this process, right?
Actually, tomorrow it's only three advocates who are going to address the court. One from the petitioner's side and two from the respondents' side. Remember that the first and second respondents have merged their grounds and have prosecuted their case together. So that they're given one chance, and then the third respondent, who is the president, will also be given a chance to be able to respond.
All right, gentlemen, I have to let you go. You've been here the whole day. But I'll start from learning from yesterday. I'll give you your closing remarks, summarize for us what happened today, and then we'll move that way.
I think what happened today, we've actually seen...
And what we expect tomorrow, just talk about that.
We've actually seen briefly a more organized approach in terms of how the petition was actually prosecuted and how it was defended. We have seen each of them being given a chance. And if you look at the first part, they actually demonstrated a very strong case. If you look at the second part, they've also demonstrated a very strong defense. So that it is left for us to see what will happen tomorrow, because now the third respondent actually comes in, but having the benefit of having had the petition itself having been argued, having had IBC, who are the principal party responsible for the conduct of the election, and them being the actual perceived benefactors of actually the process, whether it was good, whether it was bad.
Okay. All right, George. Your
I'm
summary.
second in terms of
Yes.
seniority or junior. Now, it's very important that a party and a person, when accused, must be heard. Remember, when NASA presented its case, what we had was their side. And overwhelmingly, there was an emotion towards resonating with the presentation. Then now a response is made, you're beginning to think, oh my, there's a response to each and every issue that has been raised. So every time that a person is accused, there must be a chance to give the other person, because that person probably has something to say about it. This is not to say whatsoever or howsoever about intending to predict any outcome. But I think the lessons, take-home lessons for Kenyans here and the cutaways are, if a person is accused, allow that person to be heard, because then there's always something to say about what happened or his side of the story. Hearing the side of the story is probably the best thing that could ever happen to a person who is accused. Tomorrow, we'll have the third respondent, the president, also making his case. But then there's a side issue. Because of the audit that is going on the servers, a report is going to be brought. No affidavits, nothing. It's just a report. Then they're given limited time upon which they make commentaries on those reports. And that's it. The case is closed, and we went for the judgment.
Okay.
Actually, Ken, that the adoption of that audit report will be the first agenda of the court, in my view. And once they adopt, then they'll go into the third respondent. But I must make three observations.
Kakai, they have until 5 p.m. to 5 p.m. tomorrow.
Okay, fine.
Yeah, it's
fine.
the last thing.
Okay, very good. Now, I have to make three observations, and which I think is important to make. One, we realized that there was a lot of decorum in the court. And you realize that timekeeping and management was very well observed. So we need to thank, first of all, the lawyers that were appearing for all the parties, and we also have to thank the judges, how they handled the matter in terms of decorum and time management. Two, there was good division of labor. I was very impressed by all the lawyers, especially the IEBC lawyers, how they were able to divide within themselves and give every person a chance to talk and divide the issues and tie them up with the evidence and the law. That was very well done. The third one is that you saw the quality of arguments that came from the bar, especially the lawyers, were very well researched. And so as we go into the final day of hearing, which is tomorrow, we expect the same quality of arguments to continue. Otherwise, the job was very well done by all the parties and the lawyers.
All right. And finally, you have the benefit of the least time.
Thank you very much. In my view, in closing remarks, I think germane issues have been raised in this petition. The arguments that have been presented has opened the minds of Kenyans to see what is the nature of the complaints that have been raised, to see the extent in which the electoral process was managed, to see the extent in which, if it was irregularly handled or otherwise. And it has given us great hope that tomorrow in this country we will be able to see better management of public affairs, especially electoral process. And it is good to know that the managers handling the elections then have very good reasons to demonstrate that something they did was not outside the law. That is what I get the impression that IBC people did today.
All right. Thank you very much, gentlemen. Starting with Kurgat, Duncan Okatch, George Kithi, and Kakai Kissinger.